Hello. Welcome back again, guys, to Vance Empire TV. Yeah, hope the year has started well for all of you. Yeah, sijui niseme tena Happy New Year. Okay, Happy New Year, guys. Happy New Year once again. So, let's finish up on the executive chapter because we had done part 1 and part 2. So today I will finish part 3 and part 4. Part 3 is talking about the cabinet. Then part 4 was talking about the other offices, including the office of the Attorney General. Because it's short, this one I'll finish it in some few minutes. Then we continue on with life, guys. Let's talk of the cabinet. Straight into the cabinet. The cabinet. So we are going to outline the cabinet and what it consists about. Because we normally hear the cabinet, and some of us don't know what the cabinet consists of. So the cabinet consists of the president, deputy president, the attorney general, and not fewer than, not less than 14, and not more than 22 cabinet secretaries. So if you all know, from 2010 coming onwards, ministers changed to cabinet secretaries. So instead of saying minister, you say cabinet secretary. And if you are familiar and you are okay with minister, well and good, because people will understand what you are talking about and they will know you are referring to the cabinet secretary. Let's continue. So the president shall nominate, and with the approval of the National Assembly, appoint cabinet secretary. So this one's tumeona kama kawaida vile huwa inafanyika hii. So president ana nominate vile katibu inasema, not less than 14 or not more than 22. Then forward the name to the National Assembly. Then kule wanafanyiwa vetting. I think this one we've all seen. Hata very soon kuna wengine watafanyiwa vetting. Wale juzi walinominatiwa to the cabinet. Very soon hii January kabla ishe. Na wale watafanyiwa vetting with the National Assembly, then the names will be sent back to the president, and the president now appoints the members to the cabinet officially. The cabinet secretary shall not be a member of parliament. So if you are a member of parliament, you have to resign from that position, because now you'll be a cabinet secretary. Each person appointed as a cabinet secretary assumes office by swearing or affirming faithfulness to the people and the Republic of Kenya, and obedience to this constitution before the president, and in accordance with the third schedule, and may resign by delivering a written statement of resignation to the president. The president may reassign cabinet secretary, may dismiss the cabinet secretary, and shall dismiss the cabinet secretary if required to do so by a resolution adopted under clause 6 to 10. A member of the National Assembly, supported by at least 1/4 of all members of the National Assembly, may propose a motion requiring the president to dismiss a cabinet secretary. On the ground of a gross misconduct or gross violation of a provision of this constitution or of any other law, where there are serious reasons for believing that the cabinet secretary has committed a crime under national or international law, or for gross misconduct. If a motion under clause 6 is supported by at least 1/3 of the member of the National Assembly, the Assembly shall appoint a select committee comprising 11 of its members to investigate the matter, and the select committee shall within 10 days report to the Assembly whether it finds the allegations against the cabinet secretary to be substantiated. A cabinet secretary has the right to appear and be represented before the select committee during its investigations. If the select committee reports that it finds the allegations unsubstantiated, no further proceedings shall be taken, or substantiated, the National Assembly shall afford the Cabinet Secretary an opportunity to be heard and vote whether to approve the resolution requiring the Cabinet Secretary to be dismissed. If a resolution under Clause 9(b)(2) requiring the President to dismiss a Cabinet Secretary is supported by majority of the members of the National Assembly, the Speaker shall promptly deliver the resolution to the President, and the President shall dismiss the Cabinet Secretary. Article 153. Decisions, responsibility and accountability of the Cabinet. A decision by the Cabinet shall be in writing. The Cabinet Secretaries are accountable individually and collectively to the President for the exercise of their powers and the performance of their functions. The Cabinet Secretary shall attend before a committee of the National Assembly or the Senate when required by the committee, and answer any question concerning a matter for which the Cabinet Secretary is responsible. So hii tumeona ikifanyika mawaziri wanakuwa summoned by committee responsible to their ministries, National Assembly or Senate. So sababu katiba inaruhusu hiyo, so hii huwa inafanyika. Cabinet secretaries shall act in accordance with this constitution and provide Parliament with full and regular reports concerning matters under their control. Okay. Article 154, Secretary to the Cabinet. There is established the office of Secretary to the Cabinet, which is an office in the public service. Okay. The Secretary to the Cabinet shall be nominated and, with the approval of the National Assembly, appointed by the President and may be dismissed by the President. The Secretary to the Cabinet shall have charge of the Cabinet office, be responsible, subject to the directions of the Cabinet, for arranging the business and keeping the minutes of the Cabinet, convey the decision of the Cabinet to the appropriate persons or authorities, and have other functions as directed by the Cabinet. The Secretary to the Cabinet may resign from office by giving notice in writing to the President. 155, Article 155, Principal Secretaries, these are PS, PSs. There is established the office of the Principal Secretary, which is an office in the public service. Each state department shall be under the administration of a Principal Secretary. The President shall nominate a person for appointment as Principal Secretary from among persons recommended by the Public Service Commission, and with the approval of the National Assembly, appoint Principal Secretaries. The President may reassign a Principal Secretary. A Principal Secretary may resign from office by giving notice in writing to the President. So that is more about part 3, which was talking about the Cabinet. So let's finish with part 4 that talks of other offices that are still in the Cabinet. For example, this Office of the Attorney General. The Attorney General shall be nominated by the President and with the, with the approval of the National Assembly appointed by the President. The qualifications for appointment as Attorney General are the same as for appointment to the office of the Chief Justice. The Attorney General is the principal legal advisor to the government. So huyu Attorney General ni advisor wa kisheria kwa serikali. Shall represent the national government in court or in any other legal proceedings to which the national government is a part other than criminal proceedings, and shall perform any other functions conferred on the office of the Act of Parliament or by the President. The Attorney General shall have authority with the leave of the court to appear as a friend of the court in any civil proceedings to which the government is not a party. The Attorney General shall promote, protect, and uphold the rule of law and defend the public interests. The powers of the Attorney General may be exercised in person or by subordinate officers acting in accordance with general or special instructions. There's also another office of the Director of Public Prosecutions, DPP. There is established of the office of the Director of Public Prosecution. The Director of Public Prosecution shall be nominated and, with the approval of the National Assembly, appointed by the President. So if you've discovered all these appointee of the President, they follow the same procedure from the ministers or the cabinet secretaries to the PSs to the Attorney General to this one of the DPP. Procedure ni ile ana nominate, National Assembly inafanyia vetting now ina approve, then back again to the President, then the President now appoints officially that said individual to that public office. Okay, so the qualification for appointment as Director of Public Prosecutions are the same as of the appointment as for the appointment as a judge of the High Court. Okay. So wanafaa kuwa na qualification the same kama judge wa High Court. The Director of Public Prosecutions shall have power to direct the Inspector General of the National Police Service to investigate any information or allegations of criminal conduct, and the Inspector General shall comply with any such direction. The Director of Public Prosecution shall hold office for a term of 8 years and shall not be eligible for reappointment. So their term is only one term of 8 years. 5 plus 3, 8 years, one term, and not eligible for reappointment. Okay. The Director of Public Prosecution shall exercise state powers of prosecution and may institute and undertake criminal proceedings against any person before any court other than a court martial in respect of any offense alleged to have been committed. Take over and continue any criminal proceedings commenced in any court other than a court of martial that have been instituted or undertaken by another person or authority with the permission of the person or authority, and subject to clause 7 and 8, discontinue any stage before judgment is delivered, any criminal proceedings instituted by the Director of Public Prosecutions or taken over by the Director of Public Prosecutions under paragraph B. If the discontinuance of any proceeding under clause 6C takes place after the close of the prosecution case, the defendant shall be acquitted. The Director of Public Prosecutions may not discontinue a prosecution without the permission of the court. The person of the Director of Public Prosecutions may be exercised in person or by subordinate officers acting in accordance with accordance with the general or special instructions. Number 10, Subarticle 10, the Director of Public Prosecution shall not require the consent of any person or authority for the commencement of criminal proceedings, and in the exercise of his or her powers or function shall not be under the direction or control of any person or authority. In exercising the powers conferred by this article, the Director of Public Prosecution shall have regard to the public interest, the interests of the administration of justice, and the need to prevent and avoid abuse of the legal processes. Parliament may enact legislation conferring powers of prosecution on authorities other than the Director of Public Prosecutions. 158. That is Article 158. Removal and resignation of Director of Public Prosecution. So the Director of Public Prosecution may be removed from office only on the grounds of inability to perform the functions of the said office arising from mental or physical incapacity. So these ones apply to the other public officers. Non-compliance with Chapter 6. Then bankruptcy, incompetence, or gross misconduct or misbehavior. So those are the grounds that are used to remove this DPP, this Director of Public Prosecution, from office. Let's continue to Subarticle 2. A person desiring the removal of the Director of Public Prosecution may present a petition to the Public Service Commission, which shall be in writing, setting out the alleged facts constituting the grounds for the removal of the Director. The Public Service Commission shall consider the petition, and if it is satisfied that it discloses the existence of a ground under Clause 1, it shall send the petition to the President. On receipt and examination of the petition, the President shall, within 14 days, suspend the Director of Public Prosecutions from office pending action by the President in accordance with Clause 5, and shall, acting in accordance with the advice of the Public Service Commission, appoint a tribunal consisting of 4 members from among persons who hold or have held office as a judge of the Superior Court, or who are qualified to be appointed as such. 1 advocate of at least 15 years standing nominated by the statutory body responsible for the professional regulation of advocates, and 2 other persons with experience in public affairs. The tribunal shall inquire into the matter expeditiously and report on the facts and make recommendations to the President, who shall act in accordance with the recommendations of the tribunal. The Director of Public Prosecution who is suspended from office under Clause 4 shall be entitled to half of his or her remunerations until removed from or reinstated in office. Yeah. So those are some of the advantages of these public offices. Yeah. Even if you have been suspended from office, salary bado unakula nusu 50%, while the case is continuing. Yeah. Unaendelea kupokea salary yako nusu until proven guilty or not, unarudi kwa ofisi kama kawaida. Okay, let's see the other article before we finish this chapter. The tribunal appointed under clause 4 shall elect a chairperson from among its members. A tribunal appointed under clause 4 shall be responsible for the regulation of its proceedings. And then lastly, the director of public prosecutions may resign from office by giving notice in writing to the president. So guys, that comes to the end of this chapter 9, which was talking about the executive. So tumeona executive vile ina work, ina consist which members belong to the executive and all their offices and how they are nominated and appointed into the offices. So tunamalizia chapter 10 hapo. So our next chapter will be judiciary. So tutaangalia judiciary. Judiciary ni mahakama, all the courts that are found in Kenya, from the magistrates court all the way to the Supreme Court. Hiyo ndio tutatackle next time. So we'll end this video here, but before I finish, I ask you guys to subscribe. Tell a friend to tell a friend to subscribe to Vance Empire TV. Subscribe, guys, like and comment. That one is the only way to grow this channel. I thank you all. See you on the next one.